congratulations to you. Give yourself a good hand. You're welcome. So, as you know, we this year are putting these programs online, and I just want to review for a brief moment how that works so that there are fewer questions to me about how that is supposed to happen. Those programs will be available for credit online. You can watch them online in the month after the program takes place live here in the auditorium. So for example, the program that we did on January 23rd will be available for credit from February 1 until February 28th. So, and you know, that's an example. So this program that we're doing in February will be available for credit in March only. And the reason why it's only available for that 1 month is that we have to keep track of the attendance. And if we let it go out longer than that, it becomes a problem with the record keeping. So I know that it's kind of a restricted period of time, but it's because it would be impossible for us to keep the records otherwise. Now, there's going to be one major exception to that rule, and that's the program that we did on January 23rd, the case law update right here in this room. The reason being is that due to a glitch in our system, we haven't been able to post that one online, and it's almost the end of February now. So what we're going to do is we're going to extend the period for watching the January 23rd program till the end of March. Okay, so does everybody understand that? And we hope to have that program up there pretty soon. This program will also be available in March, and also the professional responsibility program will be available in March. So you'll have 3 opportunities to watch the WICLA online presentations and get credit in March. Okay? All right, any questions about that, about how that process works? The actual logistics of it are beyond my capability to explain, but every month you're going to get an email from WICLA that'll step you right through the process. You know, click here, click there. This is how you access the program. This is how you get your certificate of attendance. This is how you fill out your course evaluation. So every month you're going to get a reminder email from WICLA how to go ahead and access those online programs. So what we're going to do today is we're going to review the commission decision summaries that you should have already received in your inbox. So as you'll recall from last year, what WICLA is going to try to do, and we've been pretty successful so far, is once every month or once every 60 days or so, we're going to try to send to all of our members a review of some recent commission decisions, you know. And then what we're going to try to do is maybe once every 2 or 3 months talk about those summaries that you received in your inbox here in this auditorium so that maybe we can flesh out some of the issues that are presented in those cases. So what you have in your written materials today is a copy of that summary that went out to you about 2 or 3 weeks ago. You should have received this in your email inbox if you're signed up as a WICLA member. So that's included as a hard copy in your written materials today. I want to compliment the authors of these summaries. So I know John does these, John Castaneda does these. I know that Katie Doan does these. Is Katie here? Okay, and there are other WICLA board members and officers who do these summaries. I think this one that you have in your written materials today and that you received in your inbox a few weeks ago was done by Katie Doan, and I can't tell you, if you haven't looked at it already or read it already, I can't tell you how great a summary of these decisions this is. It's awesome. It's way better than any other type of publication that you're getting, in my humble opinion. And so please if you're not already a WICLA member, in and of itself, I think this is something that should persuade you to join WICLA. All right? Any questions about these summaries and how you're going to receive them or anything else? Okay, great. So let's get right into the cases that are included in this summary. So right off the beginning, or right off the bat, I should say, I'm going to go off script, right? Because the Sheriff-Smith case that I want to talk about is not included in the summary that you most recently received. And that's because the Sheriff-Smith case came down after that summary had already been done. And I think it's an important enough case for us to talk about that I included it as the first slide in this presentation, even though it's not included in that summary that you previously received. And the reason why I think that this case is so important is that it seems to represent maybe the logical or illogical extension of that Dukich case that we talked about, last month, right? The slip and fall on the rainwater that the appellate court said is not any risk greater than the general public. So what Sheriff-Smith represents is a parking lot case, right? The familiar parking lot case that we all know about. What Sheriff-Smith slipped on in the parking lot, though, was snow. And remember when we were here talking about Dukich last month, we were talking a lot about the distinction between rainwater and snow. Why is snow different from rainwater? Well, here's a case, Sheriff-Smith, in which the commission decided that snow is not a hazard, okay? Because in this particular case, the commission found that it was a natural accumulation of snow. And the commission now, as far as I can tell, for the first time, has said that a natural accumulation of snow is not a risk that arises out of the employment, right? And let's just talk a little bit about the Sheriff-Smith case. So it's Sheriff-Smith versus Manhattan Park District. In this case, the arbitrator had awarded benefits to Ms. Smith when she slips and falls on snow in the parking lot that is owned by her employer. So this parking lot is owned by the Park District. And she parked in the parking lot, and as she was leaving work on that day, she slips and falls on snow. The arbitrator analyzes those facts and says she's in the course of her employment because it's a parking lot owned by the employer, right? Owned by the employer. And we all know those 3 or 4 words that are important in parking lot cases, right? Owned, maintained, managed, or controlled by the employer, right? Owned, maintained, managed, or controlled by the employer puts you in the course of your employment. In this case, the parking lot was owned by the employer, by the Park District. So the arbitrator says that's in the course of. The arbitrator says, look, the petitioner identified what caused her to fall. The snow that was on that parking lot that had been falling all day. Maybe the employer had tried to plow the snow at one point. Maybe they hadn't. There seems to have been some dispute about that. But in any event, the arbitrator says, look, she says that she's in the course of her employment because the parking lot's owned by the employer. She slips on snow. That's the arising out of element. She gets workers' compensation benefits. The commission reverses the arbitrator's decision on a 3-0 basis. At the very least, what the commission says is that that's not arising out of. But I think what they also seem to say is that she's not in the course of. And that's the 3rd bullet point here on the slide, right? The evidence establishes that the parking lot was open to and used by members of the general public. To me, that sounds like it's in the course of thing, right? This is, not a parking lot that is somehow controlled by the employer because the general public gets to park there. But in fact, it was owned by the employer. So I'm not sure why the commission focused on this particular element, except to maybe dispute that in the course of part of it. But the last bullet point here, I think, is the most important one, and frankly, to me, the most surprising one, right? The commission says that the accumulation of snow in the parking lot represented a natural accumulation, as there was no evidence that the respondent created or contributed to that hazard. The lot was open to the general public, and therefore it resulted in a hazard to which the general public was equally exposed. The commission finds that Smith's injury did not arise out of her employment. I don't know any other case that has ever said this, that has said that in order for snow to be arising out of, it has to be an unnatural accumulation of snow, like, you know, in a PI case, right? The kind of PI standard that, you know, we've often talked about. In fact, there are cases like, appellate court cases like Moore's Harvey, and a line of cases that, in my opinion, almost seem to say that as a matter of law, when you're in the course of your employment and you slip on snow of any kind, whether natural or unnatural, that arises out of the employment. Clearly that was the case in Moore's Harvey, right? In Moore's Harvey, which is a case we all know about, a parking lot case, petitioner slips on snow, and the appellate court says, yeah, that's good enough. She identified that she slipped on snow. There's no discussion about whether it's an unnatural accumulation or natural accumulation. Okay? So, yes, go ahead.
Two questions. One, has this been appealed?
Yes. So the question is, has it been appealed? As far as I can tell from looking at the commission website, there's been a circuit court summons filed in this case. I don't know the status of that, but according to the commission website, there's a appeal on file in the circuit court. All right? Any questions about this one? Any other comments? Yes, Mark.
David, don't you think that in Dukich, the court made a distinction between paved surface that was wet and snow, ice, etc.? I mean, that's in the Dukich.
Yes, it is. Yes, it is. And even though Dukich was not available to the commission at the time they wrote this decision, a case like Moore's Harvey certainly was available to the commission before they wrote this type of decision.
I can tell you this, my phone is ringing off the hook.
Your phone is ringing off the hook?
In the office, sure.
Why, do you run a snowplow service? You want
No, also, it's just all of a sudden, especially too, we've been out of snow recently.
All right,
A lot
well,
of questions.
I'm sorry that I brought it up because it's making Mark's phone ring off the hook. Yes.
Okay, I think there's another fact that's here that I'm concerned about. It says that they're not instructed to park in a certain place and that the member, they can park on the street. I think that changes the fact, the facts affect the decision here.
Okay, so Francine's point is they're not told to park in that parking lot. They have the choice to park in that parking lot, right? And I've included the Sheriff Smith decision because I think it's so important in your written materials. I haven't included any of the other decisions that we're going to talk about because those will be posted on the website in the next few days if you need to see them. There were like 300 pages worth of decisions, so I just couldn't make hard copies, but they'll be posted on the website. So let's talk about this idea that, right, she wasn't instructed to park in the parking lot. She had the choice of where to park in the parking lot. Well, Francine, I agree with you that that's a fact of the case, but right, those words that we talked about before that we've always understood as, at least I've always understood as workers' compensation lawyers because they're cited in the cases, are owned, maintained, managed, and controlled. That where you're directed to park is the control element, right? We control it because even though we don't own it, we direct you to park in that area. In this case, they owned it. The employer owned the parking lot. It was their premises. Their premises. As far, and I'm probably wrong. I've been wrong many, many times before. Probably wrong. But as far as I was concerned, that's where the inquiry ends in a parking lot case when you're trying to do the in the Corsa. Do they own it? Yes, you're in the Corsa. Right? Yes.
There's a recent Rule 23 decision around argument by the appellate court that the court felt had to remind the commission that the axiomatic that fault is not a part of the Workers' Compensation Act, and that fault either the petitioner or the responsible.
So Mike mentions a case called RUND, R-U-N-D, which is a recent Rule 23 decision from the appellate court, which the lawyers in that case may be filing a petition to publish that decision because it's really an important decision. So honestly, whether they publish the decision or not, we're probably going to be talking about that decision here in the next month or so. So RUND is the name of the case. Keep it in mind. It's a fall down the stairs case, and we'll probably be talking about that case again. In fact, I hope we'll be talking about the Sheriff Smith case when it gets to the appellate court. So, all right. Yes, Dave.
Again, just bringing it further, like in civil cases, it's snowing outside and people track their snow actually in the facility, owned by the employer, 10 feet from the front door, with a wall. And they say, well, the parking lot in there, that is clearly owned and controlled by the employer. Is it a natural accumulation? Unnatural accumulation? Where does this go from here?
So Dave's question is, what about if that snow was on the inside of the building, right, as opposed to being out in the parking lot? What difference does it make if she's in the course of either way, right? If she's in the course of in the parking lot or she's in the course of in the building, what difference does it make where the snow, the where part, right? We all know, right? The where part, the where, the when and the where, that's an in the course of question, right? When and where is an in the course of question, not a arising out of question, of course, unless you're a traveling employee, right? And we're going to talk about a traveling employee case here in a little bit. But unless you're a traveling employee, the when and the where kind of doesn't matter, right? But the when and where, those are questions that you ask when you're trying to analyze the in the course of element, right? When and where is not an arising out of element, right? Right? Does everybody understand that or agree with it? You probably disagree. But right, when and where is an in the course of. In this case, once it's owned, once that parking lot is owned by, it's established that that parking lot is owned by the employer, you've answered the when and the where, right? You know, in their parking lot when she's in the course of her employment. Okay? Yes, Dave.
The only reason why you're confused with all due respect to the commission, this wasn't the best decision they've ever made.
No, Dave, I'm often confused even with good decisions. So.
In terms of the natural accumulation, we know that that is just dictated. The real issue is what Francine pointed out. Does this arise out of employment? Is this like the Walmart case 3 years ago, where you have a mixed use or only employees or public use? That's going to be the crux of this case. Because if you look at natural accumulation, that means if my wife proved that I felt it was an unnatural accumulation, she'll be able to claim loss of consortium against her. Because it's negligence and personal injury law, and it's nonsense.
So Dave, all due respect, right? I think what you're talking about is in the course of, right? I think what you're talking about is in the course of. And if that's what the commission decided, that she was not in the course of her employment when she was out there in that parking lot, right? Because it was open to the general public. Anybody could park there. She's not in the course of her employment. Then the arising out of issue is moot, right? They shouldn't even have gotten to the arising out of issue. If she's not in the course of her employment, what difference does it make whether it was an unnatural or natural accumulation? So I agree that the parking lot cases begin with an in the course of analysis. They always begin with an, are you in the course of your employment when you're out there in that parking lot, right? Because clearly she wasn't working, right? She was going out to her car after the end of her day. It wasn't like she's an employee of Jewel sent by her manager out to get a shopping cart in the parking lot because it's snowing, right? Oh, you're already working. We got to get those shopping carts in. But let's assume that it was that, right? Clearly in the course of, no question. The boss says, go out and get that shopping cart because it's snowing. Now do you have to prove that it's an unnatural accumulation of snow? Because the same rule applies, right? There's members of the general public out there in that parking lot, right? Right? So what's the difference? Once you've decided that somebody's in the course of their employment, then you move on to the arising out. And I agree that perhaps what the commission could have decided here was that she's not in the course of her employment, although they had the problem that the respondent owned the premises. It was their premises. And as we all know, even when you're coming into or leaving your employment, there's that little zone of safety when you're on your employer's premises, right? How do you get off of their premises without traversing that snow, right? You can't go home for the night, right? So we all know that there's that little zone of safety that extends beyond your work hours and, you know, outside of the door of right? When they own the premises. Right? So, all right, any other questions? I'm glad that we spent some time on that one because that's a really important one. So let's take a look at Mark Hoffman versus Advanced Mechanical, which is a case that involves issues of when is the employment contract completed and another arising out of case. All right, so here's the kind of general facts in Mark Hoffman, right? He goes to interview. He's a union member, I forget, a plumber or something. He goes to interview at the employer's premises. The employer says, yeah, you're hired. You know, here's a little safety training. Here's a uniform. Here's a, you know, a guidebook or whatever, a handbook. And you're going to be scheduled to work at a site, you know, such and such ABC site, right, off the premises of the employer. But before you go there to the site, you got to go to our clinic and pass a drug test, right? So that's the facts and circumstances of the case. Mark Hoffman goes to the clinic. He takes his drug test. Some question about whether he's told, and we'll see how that fits in later, some question about whether he's told whether he's passed the drug test or not. And as he's leaving the premises of the clinic where he took the drug test, bang, goes down, hurts his back, right? Arbitrator awards benefits in the case, and the commission affirms that, right? And what the arbitrator, on a 2-to-1 decision, there's a dissent which we're going to talk about. What the arbitrator says in that case is that, sure, he was hired, you know, when he was told, okay, the last thing you got to do is go and take that drug test, you know, and if you pass the drug test, then you go straight to the site, right? In fact, he passed the drug test, right? It turns out in retrospect that he actually was clean and he passed the drug test, and that was significant to the arbitrator who said, look, he's in the course of his employment, right? He's already been employed by the employer when they send him to take the drug test, and it arises out of the employment, right? Here's another slip and fall, right? As far as I can tell, there's no reason identified about why he fell on the premises of the clinic, and so why does the arbitrator find that that's arising out of? Because he's a traveling employee, right? He's a traveling employee. The employer directed him, go to the clinic and take the drug test. When he's going to the clinic to take the drug test, okay, and until he completes the drug test, he's a traveling employee. So there's the arising out of element. You don't have to say it was an unnatural accumulation of snow. You don't have to say that it was rainwater. You don't have to say it was anything, right? Is it reasonably foreseeable that somebody who's going to take a drug test would slip and fall as they're coming out of the premises? I suppose if they fail the drug test, there's even more reason to believe that they're going to slip and fall, right? So it's, what the arbitrator says, look, this happening was reasonably foreseeable to the employer, and therefore, we don't really even have to get into the arising out of analysis that we talk about when it's not a traveling employee. So, that's the holding in this case. Employed when he goes to take the drug test in the course of his employment, because he's a traveling employee, there's the arising out of element when he slips and falls, right? Commission, one dissenter. What the dissenter says is that he wasn't even an employee when he went to take the drug test, because the last act necessary, you know, that kind of phrase that we hear about in the jurisdiction cases, right? The last act necessary to complete the employment, if that happened in Illinois, then the contract of hire was made in Illinois. That analysis is used by the dissenter here to say, until he passes the drug test and shows up at the job site where the employer has assigned him, he's not even yet employed, right? He's not in the course of his employment because he's not an employee at the time when he's taking the drug test. And the dissenter said, it doesn't matter whether he passed it or failed the drug test, the fact that he was, that the last act necessary to complete the employment had not occurred, right? That he had not shown up at the job site, that means he's not in the course of his employment because he's not employed yet, right? But just as an added added kind of little additional thing, the dissenter says, look, it wouldn't have arisen out of anyway, right? Because he's not a traveling employee, right? He works at a job site, right? So he's not a traveling employee. So that analysis wouldn't have helped him anyway. All right. Any questions about this one? Any comments, concerns? All right. Bumpfist is an interesting case. Because as far as I can tell, this was a pro se case. The petitioner tried this case pro se. Does anybody know anything about this case? All right, it's a case from downstate. It's a mental case, and the arbitrator denied benefits in this case, and the commission affirmed that denial of benefits. Not too much reason to spend a whole heck of a lot of time on this, other than this idea that in order to succeed in these mental cases, what the commission reminds us is that there's got to be a severe, sudden emotional shock, right? Severe, sudden emotional shock. And what Mr. Bumpfist said here was, you know, he presented one of these kinds of my job stinks cases, right? My boss is mean to me cases, you know, like we were joking about in my office the other day, that Jerky Boys. Are any of you old enough to remember the Jerky Boys who used to do the prank phone calls? You know, they did the prank phone call to the lawyer saying, I got a case, my boss called me a bad name and it hurt my feelings, you know? And the lawyer's like, yeah, I don't want this case, click, right? So that's the kind of case that Mr. Bumpfist presented, as far as I can tell, on a pro se basis. I think he's filed a summons to the circuit court, so you may see Mr. Bumpfist in the future. In fact, if he wins his case, we'll bring him in here to present. So. All right, any questions about this one? Okay. All right. So Nicolasa Gaetan versus Flanders is an important case because it reminds us about this idea of when a worker is traveling to a medical appointment, is she in the course of her employment, right? So this issue comes up a lot, right? This idea that, you know, I was going to a medical appointment for my workers' compensation case, and therefore when I get injured while I'm going to that medical appointment, that's part of my workers' compensation case, right? It's not an intervening injury, it's all part of my workers' compensation case. Well, in this particular case, Ms. Gaetan lost on those facts. The facts are a little complicated here, but there's at least some indication that the initial medical treatment was provided to Ms. Gaetan at the clinic where she was going because the employer drove her there. The employer actually drove her to that clinic. So this was a follow-up visit when she was injured, and the facts seem to indicate that she was working on that day, and the boss reminded her, oh, you've got a 1 o'clock appointment at the clinic, and one of the other employees or supervisors said, oh, I'm going right by the clinic, so why don't you follow me in your car as we drive right by the clinic so you can kind of get there. So there was maybe a little bit more direction than normal in terms of what the employer was doing in terms of directing the medical treatment to that clinic, but not enough for the arbitrator commission to award benefits when on her way to that follow-up medical appointment, she gets into a car accident, right? So what the commission reminds us is that there's this, and I think this guy's name is pronounced Lucius Lee, but in our office we love to call him Luscious Lee. So in the Luscious Lee case, the Supreme Court told us, look, when you're going to a medical appointment for your workers' compensation case, it's not covered under workers' compensation because you have the choice of when you go and when you don't go. In Ms. Gaitan's case, it wasn't so clear whether she had the choice, right? The boss said, hey, don't forget your appointment's at 1 o'clock today. Come follow me. I'll take you right by the place where I actually driven you the last time you went there. But in any event, that wasn't enough to make it part of the workers' compensation case. Okay, so any questions about this? You often get these questions about, if I'm going to an IME, right? On my way to an IME, if I get T-boned, is that part of the workers' compensation case? Anybody had one of those cases? Yeah, how'd it go? Oh, yeah, you're right. No, I'm sorry, you're right. Yeah, John, tell us about that. Go ahead.
There's a case law in the IME.
Yeah. You're right. I'm sorry. I went off track there. The IME, going to an IME is compensable, right? Because there's the direction there, right? Oh, it's not. I'm sorry. Look at me. Okay. John, you do this next time. Yes?
I'm just wondering, would it make a difference if the employee is being paid?
Yeah, I don't know, right? So the question for Mark does it make a difference if the employee is being paid? I don't know. I mean, what about if this was part of, remember the PPPs that were created a few years ago, right? What if this clinic is in the PPP? Is there more direction there? Maybe, so. All right, any other questions? Yes, Tom?
So if the employer isn't telling the employee that you got a right to go, there's more than just told the employee for this day, then it would be related.
So Tom's question is, what if there was that direction, right? What if the employer said, I don't care, it's 1 o'clock, you're going to that clinic, get in my car and we're driving there, right? I suppose the facts might be different under those circumstances, right? You might be a traveling employee at that point, right? You're on a special mission for the employer, right? Yes.
Dave, does the case stand for the proposition that if the petitioner goes to the company clinic a second time, he's exercising his first choice position?
Wow. So I didn't even consider that. Ray's question is, well, if you're not directed to go there the second time, is the second time you go there, is that now your choice?
Suppose the doctor the first time says, okay, do this, do that, and come back in 2 weeks.
Well,
go back a second time, are you exercising your first choice?
So the question is, are you exercising your choice if you continue to go back? I hope this case doesn't stand for that proposition, but we've seen extensions of these kinds of cases before. So, all right. Anything else? Okay, good. So the next case is Timothy Scoreppa versus Berwyn Park and Berwyn Police. Okay, why are there 2 respondents in this case? Because there's some confusion about who Scoreppa was working for at the time of the injury. So here are just the general facts. I'm going to try and get through them real quick. So he's a Berwyn police officer, but on the date of the injury, at the time he's hurt, he's actually working in his second job for the Berwyn Park District, whose police officers or security guards are all Berwyn police officers, right? So all the Park District security guards are also Berwyn police officers. But on this particular day, he's driving in the Berwyn Park District car, and he's not on duty for the police department. He's going from one park to another, and as he's going from one park to another, he sees a car spin out, in front of him, and you know, he hears on his police radio, which he has in his Park District car, that, you know, we're trying to apprehend a suspect, you know, all points bulletin or whatever, you know, the police say, like I see on TV, right? And so he gets out of his car and he's like, you know, stop right there, right? And the defendant said, or the alleged defendant says, yeah, I don't care, and comes by and clips him, right? And that's how he gets hurt. So the question is, who's he working for at that time, right? Because as a Park District security officer, he wouldn't have had any authority to make that arrest, right, of that perpetrator, because that's not on Park District property. That's for the police department to be doing. But what the arbitrator and the commission end up saying is that he's an employee of the Park District at the time that this injury happens, even though he was responding to something that the Park District says, hey, wait a second, you were responding as a police officer. You weren't on Park District land. You weren't, you know, doing Park District duties. You were responding as a police officer to this, and the arbitrator and commission said, yeah, too bad, Park District, you're on the hook for this. So I asked the lawyer who had the petitioner in this case, what was the deal here? I mean, Berwyn Park, Berwyn Police, what's the difference? It's all Berwyn. He said, no, it isn't, right? Because they're different taxing bodies, right? The money comes out of a different pocket depending on who the employer was. So that's why there was an issue here about who he was employed by, right? Okay, this one maybe is, even the commission says this is a unique case, but it was interesting, so I thought I'd talk about it. All right, anything else? Okay, good. All right, let's talk about Ken Olszewski versus City of Highland Park. In this case, the commission reverses an arbitrator awards of benefits. So this is an important case, right? Because here's a commission reversing an award of benefits. In this particular case, I'm sorry. I'm going too fast. So I'm going to try and slow down for a second. The commission reverses the arbitrator and awards benefits, right? So the commission awarded benefits in this case, even though the arbitrator had denied benefits. And the arbitrator had denied the benefits in this case because the arbitrator had found that the petitioner was engaged in a voluntary recreational activity under Section 11, right? So the arbitrator denies benefits, the commission reverses on a 3-0 decision and awards the petitioner's benefits and says, no, he was not engaged in a voluntary recreational activity. Here's the facts of the case. He's a firefighter for the City of Highland Park. There's a lot of testimony and a lot of documents introduced into evidence that indicate that for 1 hour per day, firefighters are required to engage in some type of physical exercise when they're on their 24-hour shift, right? So on their 24-hour shift, 1 hour of that time, they're supposed to be engaging in some type of physical fitness activity. In this case, Ken Olszewski was bench pressing on the bench press machine that they had at the fire station, right? And he was doing what he considered to be his mandatory 1 hour of physical activity. And that makes it enough to trump the voluntary recreational activity preclusion in Section 11, according to the commission, that there was some mandatory nature of this physical activity. And even though he had a choice of what he could do, you know, he didn't have to be bench pressing when he blew out his shoulder. He could have been doing the treadmill and blew out a knee instead, or whatever, right? The fact that it was somehow mandatory is what trumps the voluntary recreational activity part of Section 11. But what's interesting is that the commission actually goes on to say that even if it weren't mandatory, that the personal comfort doctrine might have trumped the voluntary recreational activity preclusion anyway, right? Because, you know, while, you know, 24 hours at a fire station, if there's not a lot of calls, gets a little boring, and maybe you want to engage in some physical activity. And by the way, when you're engaging in some physical activity at the fire station, that helps everybody, right? It helps not only the fire department, but it helps the community at large, because we want really, you know, fit firefighters out there being able to fight fires. So either it's a mandatory activity It's not voluntary recreational activity, or it's the personal comfort doctrine. Either way, the commission says that this should be covered under workers' comp. Right? Any questions about this one? Any issues? So the reason why I bring this case up is, right, if you're involved with one of these voluntary recreational activities cases and you don't have that kind of mandatory thing going on, right, think about the personal comfort doctrine as a way to maybe fight against that voluntary recreational activity preclusion. Okay? All right. Let's talk about Vernell Dixon, which is not really a mental case like Mr. Bumpus's case was, but is, kind of talks about those issues. So in this case, the commission affirms the denial of benefits. The arbitrator had denied benefits, and the commission affirms that on a 3-0 decision. So really quickly, the facts of Vernell Dixon are that he's a CTA bus driver, and he's driving the bus. A couple gets on. The female passenger pays with a fare card. The fare card goes through for her. She tries to pay for her male counterpart, and the fare card doesn't work, right? And so the bus driver is like, hey, you got to pay, or, get off the bus or whatever. And the guy spits at the bus driver, right? And there's some question about whether the spit got through the safety shield, that protects the bus driver, or whether it didn't. Ultimately, what the bus driver does is the guy gets off the bus, then gets back on the bus, and is heading toward the back exit of the bus, and the bus driver says, yeah, enough's enough. Unbuckles the seatbelt, walks down the aisle of the bus, right, and is going to beat the you-know-what out of the guy, right? Except that the guy and his female counterpart beat the you-know-what out of the bus driver, right? The female jumps on his back, choke holds him, the guy's pounding him, right? And so he says, look, that's a workers' compensation case, right? I'm in the course of my employment as a bus driver. I got the bleep beat out of me by some passengers. What's to argue about here? Well, what's to argue about is not the in the course of, right? Because the commission says he's in the course of all day long. What the commission says is once he unbuckled that seatbelt and went to go get the guy, right, that no longer arises out of the employment, because he was no longer performing a duty of his job, although one would think that a duty of your job is to make sure that non-paying passengers don't take a free ride. Although there's an interesting thing in this decision, which you'll see when it's posted online. Apparently the CTA's got like a 2 warning rule, right? Like if somebody gets on and says, I'm not paying a fare, I don't know that they want this out there in the general public, but apparently there's a 2 warning rule. So, you don't pay your fare, the bus driver says, get off the bus. No. The bus driver says, get off the bus. No. You know what the bus driver is supposed to do? Drive on, right? That according to the rule that's announced in this case, that you're supposed to drive on. So I'm not paying the next time I get on the bus. So, only kidding, CTA, only kidding. So, but in any event, so when he unbuckles his seatbelt to go get the guy, what the commission says, or the arbitrator, because it's firm adopted, says, look, he was trying to get what's the word they use? Retribution or something against the guy, and therefore it no longer arises out of his employment. And by the way, the commission says, just for good measure, even if it still arose out of the employment, the bus driver was the aggressor, right? So it's the aggressor defense in an assault case. You can't be the aggressor. Okay. All right. Oh. So, okay. All right. Anything else? Yes, Tom. Tom's got a very creative theory about this case, right? So this being spit upon is a severe, sudden emotional shock, right? And so he's temporarily insane when he when he goes after the guy, right? And the proof that he's insane is he gets the living bleep beat out of him, So there's an interesting theory. Tom, I wouldn't take this case though if it came to the door.
Somebody spit at him. I have a CTA
to pay. CTA people are supposed to do nothing. Sit there and take it.
Read, when it's posted, read the case and see what you think about it. But, you know, Mike makes the point, right? It's no fun to get spit on, right? You know, so, right? All right. Okay, any questions, any concerns? Okay, good. All right, Richard Powell versus Manchester Paint. I know there are people in this room who know more about this case than I do, but it's a case that involves a cut-off of temporary total disability benefits. And in this particular case, the commission takes away, modifies down some of the temporary total disability benefits that were awarded to the petitioner. And the reason being the commission does that is because they say that the petitioner refused to do light-duty work, right? So the reason why this case is important is that it reminds us of that exception to the interstate scaffolding rule, right? The interstate scaffolding rule is the dispositive question in a TTD case is whether the petitioner's reached MMI, right? Except that there's these 3 or 4 exceptions, one of which is if he's offered light-duty employment and he unreasonably refuses to do the light-duty employment, then that's an exception to the MMI dispositive rule of interstate scaffolding. In this particular case, apparently there was some surveillance evidence that Mr. Powell was exceeding his restrictions and that the job that had been offered to him would have been within the restrictions that he had placed on him. All right, any questions about this one? Any concerns? Any comments? Okay. I'm not going to be able to pronounce the, and I hate to be ethnocentric or something about this, but there's one of my Greek friends who want to help me pronounce the name here. John, okay, John Advis, right? John Advis, who's the widower of Sophia Advis versus North Park University. So what is this case about? This case is about whether an award survives or whether benefits, permanent partial disability benefits, survive the death, the unrelated death of the petitioner, right? So this is a pretty, you know, we encounter this all the time, and every time I encounter it, I'm confused, right? I'm like, does it survive? Does it not survive? I can't remember. Is it 8E19? Is it 8H? Well, here's a case that pretty much tells us that even if it's a man as a whole award, right, it survives the unrelated death, right? Even if it's a man as a whole award or benefits, it survives the unrelated death of the petitioner. All right? Real quickly, here you can see the timeline here, you know, the date of accident, the TTD that was awarded, the maintenance that was awarded, the date of death, right? The arbitrator had awarded 60% loss of use of the left leg. The commission decided that that should be converted into a man as a whole because it was a back injury. I'm not sure why the arbitrator converted it to a leg other than, you know, I think some of us have a bit more confidence that 8E19 applies, which is for the specific losses, then we have confidence that 8H applies, which is for everything else, right? So I think maybe there was some kind of thinking like that. In any event, the commission says, look, this is a back case. It's not a leg case. We're going to convert this to a person as a whole, but even though we converted it to a person as a whole, it survives the death of the petitioner pursuant to Section 8H, which doesn't, which isn't in Section 8E, which is the specific loss section. All right. In this particular case, the petitioner had a widower who is one of the named takers under Section 8H. But don't forget there's that Bell case out there, right, which we've talked about here in this room a couple of years ago, that says that even if there isn't one of those proper takers, the estate of the petitioner is always a proper taker, right? The petitioner's estate, and whether you have a lot of money or a little bit of money, everybody who dies has an estate, right? And so I don't think this case is limited necessarily to the widower because of that Bell case. I think what it says is that even if it's a man as a whole, it survives, right? And since everybody has an estate, it all survives, right? Even if there is not a proper taker, right? Does everybody, questions, concerns? Yes.
Did they take the entire amount of the award provided, or just the weeks?
Yeah, so it's interesting here because, you know, by the time this case was tried, I think it was all accrued anyway, right? I think it was all accrued, but that's really an interesting issue, right? I think it's a, you know, what's already accrued. If you look at the arbitrator's decision here, and I'll grab it here in a second if I can find it real quick. You know that last paragraph at the end of the order where the arbitrator says, you know, the petitioner is entitled to all of the benefits from such and such a date through such and such a date, right, that have accrued through such and such a date. There was an interesting paragraph in that order that I'm going to try and pull out as I'm talking about another case, all right? So you're right, this question still begs the question, or this case still begs the question about, you know, what's already accrued, what isn't accrued. But I think this case stands for the proposition that whether it's accrued or not, it passes to the estate. So I don't know if that means you have to, or passes to the widower. I don't know if that means you have to pay what's already accrued and then pay the widower week by week by week, right, if it's not already accrued. But I don't think there's any distinction in this case that says that it's got to be accrued or unaccrued, right? At least not in this case, right? Okay. All right, anything else? Any other questions? All right. Timothy Simmons is an interesting case because it's a disfigurement case under Section 8C, in which the Commission tells us that the 8.1b analysis, you know, the 5 factors that we've talked about ad nauseum here in this room, that those factors do not apply, that 8.1b does not apply to a disfigurement case, okay? Even though in the AMA guides there's a chapter on burns, there's a chapter on skin conditions, okay? That the 8.1b analysis does not apply to disfigurement cases under Section 8C. The arbitrator did apply the 8.1b analysis, and in applying the 8.1b analysis had awarded 120 weeks of disfigurement under Section 8C. The Commission says you don't have to and you shouldn't apply the 8.1b analysis to disfigurement, and reduces the award to 100 weeks of benefits. Okay? The dissenter at the Commission level flips it around and says, no, you should have applied the 8.1b analysis, and by the way, I would have only awarded 30% of the leg, which is 64.5 weeks. All right, so I would have awarded even less than what the Commission had modified it down to. So clearly, 8C, you don't have to apply the 8.1b analysis, right? But look what the Commission says about 8D awards, right? You know, that the 8.1b analysis does not apply to 8, or does apply to 8D, right? So look what it says here. First, the arbitrator reviewed, blah, blah, blah. The Act specifies these factors are intended to be considered specifically in the context of permanent partial disability. In other words, in cases involving determinations of benefits under Section 8D or 8E. That's when 8.1b applies, 8D or 8E. Well, what's included in 8D? Right? What's included in 8D? 8D1 and 8D2, right? So the question is this the Commission telling us that the 8.1b 5-factor analysis applies in 8D1 wage differential cases, or 8D2 partial incapacity from, the loss of trade cases, right? Right? Does the 8.1b analysis? I don't know. They went a little. They could have just said it doesn't apply to 8C. They didn't have to tell us that it applied to 8D and 8E, but that's what they said here. So just keep your eye on that, right? Any questions? Any issues? Okay, good. Real quickly, this is a modified down by the Commission, which is Mark Grady versus City of Bloomington, and this is an application of the 8.1b analysis. The Commission didn't like the way the arbitrator had applied the 8.1b analysis and reapplied the 8.1b analysis to modify down the award from 15% of the left hand to 10% of the left hand. The most important issue that the Commission weighed, which felt that the arbitrator had not weighed, was this future earning capacity thing. right? They said, the commission said, look, the petitioner did not put on any evidence that this has affected the future earning capacity factor of section 8.1b. Therefore, we're going to give that some weight to bring it down, right? The fact that you couldn't show that it had some impact on your future earning capacity brings the award down a little bit. All right, and not a little bit, I mean, 50% reduction. So, all right, any a third, 33% reduction, excuse me. Any questions, any concerns about this one? Okay, good. Robert Brock is an interesting case because in this particular case, the arbitrator had awarded a wage differential benefit. So in this case, Mr. Brock was a welder, and I know I'm past time, but let me quickly get through this. He's a welder, and he's injured. He does a self-directed job search, right? Because apparently the respondent had not provided vocational rehabilitation for him. He does a self-directed job search. He can't find work as a welder. Instead, he goes to work as a maintenance man. On the basis of his work as a maintenance man, the arbitrator awards him a wage differential, right? The commission takes it away, right? The commission vacates the wage differential award and says, no wage differential for this guy. Instead, they say that the respondent must provide vocational rehabilitation for Mr. Brock, even though apparently he was asking for a wage differential, right? The respondent must provide vocational rehabilitation and authorize the enrollment of petitioner in a vocational rehabilitation program. Look at this. With the objective being to return the petitioner to work as a welder, okay? Talk about a narrow vocational rehabilitation program, right? So the petitioner's expert here was June Blaine, I think her name is, and the respondent's expert was Joe Belmonte. Joe Belmonte said, look, I think I can find this guy a job as a welder. And the commission said, okay, you better now, because that's what we're awarding, right? We're awarding you a vocational rehabilitation program that has its maybe only objective of finding the petitioner work as a welder. You're going to get maintenance while you're engaged in that vocational rehabilitation program, but Mr. Brock had already moved on, right? He had said, okay, if I can't go to work as a welder, I'll go to work as a maintenance man. Give me my wage differential. So my concern about this case is that it seems like it's 2 bites at the apple for the respondent, right? They didn't give him the vocational rehabilitation before he tried his case, right? But now they're able to give him the vocational rehabilitation, after he's already tried his case, and that's the concern that I have about this case. Any questions? Any concerns? Yes, Dave.
What if he goes through the program, cooperates, everybody does what they're supposed to? And after 6 months or so, it ain't working, and everybody agrees to it. And then are they violating the order if they say, oh,
I know Joe would take this in the spirit in which it's meant. Joe will refund the money under those circumstances. Only kidding, Joe. All right, thank you. Thanks, everybody.